usually your primary eye is on having everything in place so that if you become incompetent, somebody
Right.
can manage your assets. And then, but even more importantly to most of our clients is that when they pass away, that they can do some really cool stuff. They can be very specific about when stuff's paid out, how much is paid out to who. They have all that wonderful control rather than dumping it in their children's laps, which often is a mistake, we know as lawyers. And you can do it without going through probate. It's instantaneous, no judge, no court. It's just incredibly better than the alternative, which is probate.
Life's Third Act is a podcast dedicated to helping you get the most out of your retirement. Sponsored by Tucker Allen, attorney CPA Joe Cordell features guests each week to discuss prominent topics for those over 55. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. Today we're going to return to talking about something that you probably saw in what I think was the last episode, depending on how we air these. And I think it was our last episode where we introduced you to kind of the three legs of a stool, and we talked primarily about the importance and the power of a durable power of attorney, as well as a health decision authority. What's this one called in Missouri?
The healthcare power of attorney. And yeah.
Okay, you can call it healthcare power of attorney. But the point is, those are two critical components to any estate plan. We argued last time in terms of urgency. One could argue that those are probably the things you should do first, and it turns out they're most inexpensive. So that's great.
Yes.
Now we're going to talk about, though, the other leg to that stool, which I'll argue is really the most powerful thing you can do. It may not have the urgency of the other things, but once those two things are taken care of, the durable powers of attorney, then you've got to turn to this. And we're going to talk about a trust, a revocable trust, in a way that we want this to be interesting to you and helpful to you, so we know that this topic has great potential to be boring. So I promise you we'll keep this as brief as we can, and we'll get to the point. And if you'll hang with us, I think that you'll find that you'll understand why trusts are talked about so much. You hear it, I suspect, in any estate planning sort of seminar you might have gone to, or conversations with people, whether it's your financial planner or others, they'll often mention trusts. Well, trusts are talked about a lot because they're so powerful. When you hear something that is used that commonly, you can be sure there's a reason. And we're going to talk about those reasons briefly today, but we'll highlight the most important things. With us is Nina Windsor. She's the managing attorney of Tucker Allen. And she, of course, is the authority on this topic. So we'll rely on Nina to sort of bring this in. Jill is, as always, the voice of the viewer. Is that fair to say?
I think that describes me well.
That's what we aspire, is that she will anticipate questions that you might be having.
I represent the people.
Yes, you're the people's representative, duly elected.
Right.
In any case, will you go ahead and introduce this topic, Nina?
Absolutely, Mr. Cordell, and thank you for having me.
Mm-hmm.
So today we're going to talk about revocable trusts. Revocable trusts are very different than something that people use to get things out of their name. So they are not to be confused with irrevocable trusts. Revocable trusts allow the greatest control for the client. They are a living, breathing document that can be changed over time. And the reason that they exist is to allow an individual or a couple to delineate what they want to have happen at the passing of one or both of them, and to really gather their assets together and put a comprehensive plan in place for both their assets and for their loved ones.
And can we say then that if this is really nothing but an agreement in which people transfer their assets to this thing that's called a trust, and really it's to another person or an institution, and that person or institution promises to manage those assets according to the instructions that are given by the person who creates the trust?
Precisely. Particularly, this person is called your trustee. What's kind of confusing with the trust to begin with is that at the beginning, the person who starts it or the couple who creates this trust are called a grantor, but they are also the trustee. So you are not relinquishing any control by creating this document because you are both the person that's creating it
that
and the
wouldn't
trustee.
be the case with the irrevocable trust.
Correct.
Okay, so it's opposite.
Most of the time.
And I want this to kind of make sense is you have these roles. You have sometimes it's called incidentally a trustor, which I'm tempted to use that phrase. Grantor, of course, is the most common phrase, but sometimes I want this to be clear to you, so I'm going to call it trustor for a minute. So the trustor is the person that says, I need to create a trust. That's you. And you say, gee, how do I do this? Well, I need somebody to whom I give the authority to run this trust according to my instructions. And that person or entity is called a trustee. So what's happening is you're transferring these to that entity. So the way that you end up being the trustor and the trustee at the same time, the way Nina was talking about, is because when it starts out, you're wearing two hats. You're creating it, but guess what? You get to call yourself the trustee. And that's okay as long as it's a revocable trust. It doesn't matter. So you may say, well, why would I bother doing that? Because you've set things up so that the moment something happens to you, heart attack, stroke, you get hit by a bus, whatever it is, your document says who the successor trustee is. So people name one, two, or three people to come after them the moment they can't do it.
Yes.
And that's triggered. That's triggered by this event. And so that means instantaneously, without a judge having to rule on it 2 weeks later and $10,000 later, instead, 5 minutes after you've been struck, this person is legally in the position to run things for you, to do the things that otherwise you'd have to run to courthouse and get authority.
So I've got a question about that. So you named these successors, say 3 of them. Are they all in control at the same time, or do you name them okay, I want, Joe Smith.
We haven't mentioned the third person yet.
A third person?
Yeah, you mentioned a third, but we haven't mentioned a third.
Okay, well,
so depending on how many successors you want to name, if you're confident of who those people are, you just want to make sure you have plenty of options. If one of them is unwilling or unable to serve, you're going back to the co-trustees or the co-agents like we talked about in the last program, and that is you can, for accountability purposes, you can name people to act jointly.
right.
And if one of them is unwilling or unable, you can designate that the remaining one would serve. Generally, because everyone that you are going to appoint is usually an adult with other responsibilities, it is preferred both by financial institutions that are dealing with this trust and by the people who end up having the responsibility
Right.
to have one person, because otherwise every step of the way you have to come to an agreement on every minute detail of what is administered with this trust.
So if person number 1 for some reason can't do it, then they'd go to the next person that's on that list.
Correct.
Okay, I gotcha.
And now talk about this third. There's a third party to this thing called a trust, and we just talked about the first two.
As far as the trust,
The beneficiary.
the beneficiaries, yes. So the beneficiaries, as you mentioned, can be entities, normally your family, your descendants, or your siblings or your friends, depending on who you'd like to provide for, which we can do in any fashion. Or they can be entities. They can be charities. So a trust provides for both a succession plan and a legacy plan for your family, but it can also demonstrate your charitable intent.
Okay.
Yeah. So keeping this simple, so you have a trustor, that's you, and your spouse. You can have a joint trust if you want. Sometimes some attorneys do it separately, and you're more authoritative on that. Some will let you do a joint. But either way, you have trustor, you have trustee, starting out being you, but then you think about, who's going to take over the moment something happens to us? Well, if it's you and your wife together, then your wife would assume the role, or if you're a wife, then your husband would assume the role. But the point is, if both of you are in a car accident you're both in the same car, you have this serious accident, then you've identified who the next person is that immediately has authority to start taking care of your stuff according to your rules. The other party about a beneficiary, all we're simply saying is the law requires that if you create a trust, it's got to be for the benefit of someone. So otherwise, why would you create it? So in the model examples, then it's you, it's three different people. It's you, it's the trustee. You create it, then you have the trustee, then you have the beneficiary that you're doing it for, this third party. But just like we explained to you with wearing 2 hats, you can actually wear 3. So the way it starts out, you're wearing all 3 hats. And you just have to imagine that circumstances change over time and they come apart so that each of these hats are worn by different people. But when you start out, you can have all 3 hats. Can you make that
Absolutely.
more understandable?
So the trust is actually created for your own benefit, or at least for the benefit of your spouse if you're married. So a joint revocable trust takes any assets that are held solely by you and will put them into a separate trust that is basically comes into being at your passing for the benefit of your spouse. Now, how much there's a pointing arrow or zigzagging around with the assets can just depend on what kind of assets you have and the degree of assets that you have. We try to make sure that we're very linear as far as the planning that we do. We don't want to overcomplicate things for someone who may have less than $1 million in assets. But we also want to be very careful about providing a very clear-cut picture for the family and also for the IRS about where these assets are going and how any estate tax may be applicable.
So the beneficiary will start out being you all, but then the moment that something happens, such as you're becoming incompetent, then you change trustees. But guess what? You're still the beneficiary. Mm-hmm. So you're wearing 2 hats. You're still the trustor to the extent that's relevant at that stage. It may not be. You're still the trustor. Now you're still the beneficiary. In other words, anything that's done has to be for your benefit, except the trustees change. You can't do it anymore. You're not in a position. You're maybe on a what's the word I'm looking for? Ventilator. Yeah. So you have a different person acting, but remember, you're still beneficiary. They can only do things for your benefit and your benefit only.
Okay, now question. Can you name a successor, a trustee? Can you name the attorney who created it to do that? Is that ever done, or is that not a wise idea?
You can. There isn't. It can vary by state. Whenever there's a rule created for something, even if it's in a different state, it looks, it shows that it's under a little bit of scrutiny. And so generally, we don't draft trusts that name our firm as a trustee. In our mind, it can create a conflict of interest if it doesn't automatically do so.
A lot of firms do. Or some do. Maybe more than half, I suspect. But we're just being cautious, right?
Absolutely. It's one of those things where if someone does not have an entity that they'd like to name, as far as a trust company, that if they're looking to name an entity versus an individual, and that's the broader
financial
question.
Institution to be
Absolutely,
okay.
Joe. So you can have the bigger question is, can you name somebody who isn't a person or isn't related to you in some way as a trustee? And there are specific provisions throughout that trust that allow for an independent or a corporate trustee to be placed. And you can have them as a last case scenario whether all of my children are unable or unwilling to act. They don't want the burden. They don't have the time. They're very successful. And then you can have a little bit of an impression of, I've worked with this bank. I like this entity. This is where most of my accounts are. I'm going to go ahead and name their trust company.
And sometimes the stranger is the only one you can trust.
Yes.
Isn't that scary?
It is scary, but family dynamics.
Absolutely. And it also prevents there from being strife between siblings, because if you put a hierarchy in place, unless you do it by age order, a lot of times people are miffed. Now, you won't know about it because you're no longer living, or if you're incapacitated, you might hear about it when you're not anymore.
When the corpus, that's the contents of the trust, are used up in litigation. Now,
Yes.
let me hurry to add. The reason we do trust is the probability of litigation is much lower than the probability of litigation in a will. So actually the strong point with a trust is that you're far less likely to end up in disputes like this. But you do want to not invite a disagreement. So your point's well taken. And when you talk about an institution, you mean like, for example, there are trust departments at a lot of banks.
Yes.
Still have that.
Well-known banks and some boutique banks as
And
well.
obviously, they get some sort of
That's the
compensation.
kicker. So
compensation,
yes.
right? And I'm sure it's a percentage.
it is usually a flat amount that is charged per month. That is a percentage of the holdings. And then there are some additional fees on top of that. Now, when you designate that trust company, they can provide you with a list of what their terms are for purposes of trust administration. But by the time that you pass away, the way that they handle that may have changed. So if you have named a corporate fiduciary on your trust, it's a good idea to still keep a relationship with that trust company and to get regular updates as to what they're charging and kind of look at where your finances are over time as well. Is this something that's really warranted for you? Because people get a little grandiose sometimes about what they think their estate is going to look like at the end. You don't want your estate or the trusts that are set up under your revocable trust for your children to get eaten up with fees just to try to provide them that support system.
Sure.
And to give you some idea that if you use an institutional trustee, it's probably fair to say that you need to have north of $1 million. And
I would agree.
Yeah, there are some, incidentally, that it's surprising they'll reach down between $1 million and $2 million. There may be even some who do a little below that, but your percentage is going to be higher. So the amount you pay, I think still is a bargain. I'll just grab a percentage. Say 1%. That's not unusual to hear that number. I think 1%, even between 1% and 2%, when you consider that their duty is to invest the money, get you a good rate of return without risking losing it. You have a battalion of professionals behind this, unlike your cousin Earl. I mean, I've said you have insurance.
I love it.
You have insurance if they screw up, and I suspect family members do not. So there are reasons that people choose a corporate
Absolutely.
trustee.
You can reclaim your Thanksgiving dinner.
Yeah,
There you go.
So because we definitely have some trust administrations where even if someone has retained an attorney to support them as far as making sure that they don't mess up, which can be done on kind of an a la carte basis. And that's kind of a hybrid between the two. You can get an attorney to support you as a trustee if you go, well, now I'm a trustee and I don't know what in the world I'm doing. Even with that, if there are other siblings, everything's not just going to one kid as the one beneficiary of your estate, it is very difficult to prevent there from being scrutiny between the beneficiaries if the trustee is a family member.
Yeah. So you want to be sure that since you took a lot of time to create these instructions for your trust, the rules that you've created, when do you want it paid out, how much, all the things that you're allowed to control about the way it's paid out. You've gone to a lot of trouble to do that. You don't want somebody who may be influenced by one of your children coming to them as a relative and saying, just insisting, and perhaps this person feels obligated. Maybe there's other personal factors. So you get all that when you have family. Now, don't get me wrong, most overwhelming majority of our clients use family members.
That's correct.
So all things being equal, of course, we'd want, maybe one of our children, maybe two or more of our children. Some people do that despite its shortcomings, to be trustees. So that can be done, but you just really need to think about, in your case and the personalities of your children, is someone competent to do that? It's great if you have a son or daughter who's very responsible and maybe is a CPA. I mean, if you have, or an engineer, somebody who's very detail-oriented, who's going to follow instructions that you trust, that's great. But not everybody has that in the family.
Well, and my parents do, but I am not the designated trustee of their estate plan.
That's surprising.
interesting.
And I was very, very pleased about that because I have 9 siblings, and I really don't want to be the point person
That's a
when my
rough
mother
job.
passes away.
Yeah.
9
so
kids.
They have blessedly appointed a national trust company to handle. And I'm sure that people will consult me and say, hey, is this trust company handling things properly or
Right.
what's going on with this? You understand these documents and we don't. But the burden is lifted off of my shoulders.
Right.
Yeah. That's a good example to make. Is when you have a lot of kids, it can be really tough. But
That could get really complicated.
yeah. So the trustee decision is important. But there are lots of ways to solve it, and lots of people do different things. Most use family.
Benefits and disadvantages of every designation that you're going to make. And the most important thing is another reason why we don't download things from LegalZoom. It's important to talk through these so that we can spot all of the issues and figure out what are your priorities, what is your ideal scenario, and what types of appointments align closest with that.
And give an example of the power of a trust. So you can talk a little bit about its power to take care of our client while they're alive. The trust actually, some would say the primary reason they do a trust is to take care of themselves while they're alive, to have a set of rules in place rather than just the power of attorney. So talk a little bit about that, but then talk about some of the cool stuff you can decide to do when you pass.
Absolutely. So while you're living, your revocable trust does not need to hold your assets. It doesn't provide the same level of creditor protection of things that you're trying to get, out of your name. So some people have the misconception that you're getting things far away from you. The revocable trust, by its name, allows you to put things in and out of your trust. You can transfer your primary residence into your trust. Some people are hesitant to do that. You don't have to. You can put something together that's called a beneficiary deed. Similar to the beneficiary designations on your accounts, it allows you to trigger the transfer of these assets into your trust immediately upon your passing.
No courts involved.
No courts
But
involved.
you can put these assets into it.
You can. During your lifetime, you can have them in an account that's in the name of your trust, but it's not necessary. Previously, a lot of attorneys would transfer everything right up front into this trust, and all of your accounts had your trust name on them, which it can make you feel really important, but it's not necessarily something that you have to do. So by that, it also makes it more accessible. It makes people understand that everything looks the same as it did the day before you walked into your attorney's office. The difference is that everything is very, very carefully buttoned up, that nothing's going to happen to any of those accounts where they end up in limbo, and that you have the greatest level of control. You have a first plan, a second plan. You have all these contingency plans that are clearly in these documents so that you're not just saying everything goes to Susie. Well, if Susie happens to be on disability when you pass away and you've just kicked her off of her benefits with a very minimal amount of money. So it's allowing you to have these plans that are working and can be changed at any time.
What if the client is involved in a lawsuit while they're alive and they have this revocable trust? Is it more vulnerable
Absolutely.
that it wouldn't be?
Well, wait.
Then personally holding the assets?
Let me though add a qualification though. This is something that is not automatic in trust law. When you do a revocable trust, normally your primary consideration isn't what we call asset protection while you're alive. Usually you're wanting your primary eyes on having everything in place so that if you become incompetent, somebody
Right.
can manage your assets. And then, but even more importantly to most of our clients is that when they pass away, that they can do some really cool stuff. They can be very specific about when stuff's paid out, how much is paid out to who. They have all that wonderful control rather than dumping it in their children's laps, which often is a mistake, we know as lawyers. And you can do it without going through probate. It's instantaneous, no judge, no court. It's just incredibly better than the alternative, which is probate, and which consumes a lot of the money that you would otherwise leave. But and I'll get your thoughts on this, Nina. If it's written to where when you become incompetent, then it's irrevocable at that stage. It's still a grantor trust.
Yes.
But Missouri does allow certain protection to grantor trusts, do they not, if you name somebody else who's also a beneficiary, meaning not you can still be a beneficiary, but I think someone else be. This
As
is
trustee at that time. Yes, there are points, and this is, oh gosh, we could spend a whole other day on this, on talking about what point do you want your trust to become irrevocable. So we're starting out telling you have all this control with your revocable trust, but one of the controls that you have is selecting when the trust becomes irrevocable, and that's when you start to talk about asset protection.
Yeah, so this is a little esoteric. We won't go very far down this road. It's kind of cutting edge because Missouri hasn't had many cases go to the Court of Appeals regarding its asset protection law. But Missouri actually has it's not the best asset protection laws, but it's definitely, I've seen it listed in the top 10. You hear Alaska being discussed, Wyoming, I think, is another state, Delaware, but actually Missouri, allows you to have reasonably good protection of your assets. That means from lawsuits, from creditors, et cetera. But that's a different conversation. It's not the primary thing people do when they plan for asset protection for their children. So let me be clear. We can give your children that. As a matter of fact, that's really the coolest thing, in my opinion. Think about my kids. But one of the things that I get satisfaction with my daughters is I'm thinking, I'm going to insulate them from being sued successfully, whether it's, malpractice, heaven forbid, whether, whatever it is they could possibly be sued for. These assets are protected. That we will give you with a revocable trust. What's tougher is to give it to you, meaning for you, while you're alive. That's a little tougher, and that's what Nina was referring to, where that requires a conversation if that's a goal, because it does mean you have to try to make it irrevocable at some point while you're alive. It could be when you become incompetent, but that's a different conversation. Talk more about what are the reasons somebody should want to fool with doing a revocable trust.
Versus a will.
Versus a will, yeah.
Okay. So in a will, you're setting out, all of the different provisions, which can be very specific, and it sounds great. But your goal, actually, even when you're doing a will, is to make sure that none of that stuff still ends up in probate because you're trying to put in beneficiary designations on your accounts. So people are like, okay, well, I want this will to have all of these things and everybody gets all these specific gifts of money. The goal is that none of that money ever hits the will because that means you are in a full-blown probate. So what a revocable trust allows you to do is you can have as many specific provisions as you want. You can set up specific things that have to do with your real estate. You can set up things that have to do with individual family members and needs that you know that they may have. And you can provide for your grandchildren in a certain way, but you can also make it so that the access to those funds don't end up in an account that requires a court to approve a distribution for a minor or an incapacitated person, or even just somebody that you don't want your grandkids getting money when they turn 18. I mean, I have a daughter who's going to be 18 in 2 years, and I definitely wouldn't want her getting a lump sum of cash. And I think she's actually pretty intelligent. But
yeah, it's a mistake. And I think that people don't think this through. My daughters, who I think have good judgment, and yet, do I want them to have all their assets at one time, even if they're 30? I don't think so. Now, maybe if it were very little money, but I'm not assuming that we're talking about a ton of money here. I'm assuming that we're just talking about a substantial amount. There's so many ways for that to go wrong if you give it to them all at once. Number one, they end up with a divorce.
Right.
Guess who's going to end up with half of that money in all likelihood?
The spouse.
Now, you can silo money that is considered an inheritance. And I have talked to exactly 0 people who have done
Who've
that
done it.
appropriately and opening up a separate account and keeping the money there away from, any joint accounts with their spouses and really keeping tabs on money that goes in and out of there so that you're not commingling those funds so that if you ever do get a divorce, it's not considered an asset, a marital asset. So these what are called lifetime trusts or separate trusts that you can set up for your children, they have a couple of things that you can decide about them. They can be trustees of their own lifetime trust at a certain point, but that doesn't give them that control that allows creditors or divorce to access the money.
Yeah. Imagine what an incredible benefit it is to say you're leaving $200,000 to each of your kids, and you have 2 or 3 kids, we'll say. Imagine the gift you've given them if you give it to them in an irrevocable trust that you can give it liberal terms to where there's reasonable access to them. So it's not as if you're trying to necessarily withhold it from. You're trying to give them a better gift than they could give themselves. And that means that you've given them protection from divorce, from a car accident in which they're sued, a bankruptcy in which they start a business. I mean, your kids could have wonderful judgment, and lots of very smart people still have a bankruptcy during the course of their business career.
That's correct.
It doesn't mean, incidentally, that they're not failures. Many of them become hugely successful.
Life happens.
But the point is, if that money is not inside something like this irrevocable trust that you've given your children, then it's gone. And that's the wonderful thing that you can give them by using a trust, and it becomes irrevocable in their hands, meaning they can't turn around and just revoke it, which means that they have protection.
That's correct. And you can pick any age that you think that a kid should have become a co-trustee with your trustees that you've designated and kind of get a training wheels program of like, what is a trust and how does it work? What is a health, education, maintenance, and support standard of what you're allowed to take that money out for? Does that include keggers in grad school? No, it doesn't, things like that. And you can really get an idea of how to responsibly manage those assets. And don't forget that this is something that when you finally have this trust created for you, it means it's happening on the death, usually of a parent, maybe sometimes of a grandparent. And that is a very sad time, not the best time to give a lump sum to a young adult, regardless of their age, if it's under, 25 to 30. It's a very difficult time where people can kind of rationalize choices that they might not otherwise make. So allowing them to have a little bit of a stopgap provision between them and what they're choosing to spend this money on allows the money to go a lot further. And it allows it to be invested.
So say we're talking, $200,000, the number you mentioned. Can you say, okay, a year after my death, I want my child to get $50,000 of it and then the rest of it distributed over time? Can you set it up that way?
You can have an annual right of withdrawal. Again, we're talking about a revocable trust with control. Lots of control, lots of ability to dictate how you want things to go. Remember, though, that if you have this annual unqualified right of withdrawal or an automatic distribution, that automatic distribution is now considered an asset that they have access to. So if they do have a creditor or there is a divorce, that asset they are guaranteed to take out may come into play for that.
Yeah, and that's an important point is a good attorney will write this in such a way that you give your trustee discretion over when and what to pay out to your children. Now, you can still tell them what you would like to see paid out, but as long as there's ultimately the right to say no on the part of the trustee, then that means that you do have this asset protection I was describing a few moments ago. But if you have an instruction that says the trustee shall pay out $10,000 per month or whatever it is, if you write it that way, it's probably a mistake because it means, it will be paid out, but it also means that a judgment could be obtained that would claim that. So you want to be sure and listen to your lawyers as how to write this so that you give this gift, your money, to these children in a way that is just hugely more beneficial to them, more helpful to them than just putting it in their lap, after you pass away.
It's a disaster preparedness plan for you and your spouse, but it's also one that you can go so far as to help prepare for your children. And what an empowering thing that is, because it's so nerve-wracking to have your children, leaving your home, and you want them to do well, and you want to provide them support, and you want to see them make good choices. But you also know from your own experience as an adult that things are going to happen that are unexpected. And so anything you can do to stand in the gap and provide protections for what you're trying to leave for your children is an enormous benefit.
Those are great words to close with. That kind of sums up kind of much of what we said.
Good job, Nina.
Yes. So next time what we'll do is we will talk a little bit more about what assets you want to put in a trust if you create it versus those you don't, and compare that to the probate process if you were to say, I don't want to fool with a revocable trust, I just want to use a will. So we'll talk about what those differences are and a little bit about the probate process next time. Be sure and hit the like and subscribe button. We really count on that. You guys know how this works. I mean, if we don't get the likes and subscribes, then not many people get to see this video. So we really work hard to make this valuable. We hope we don't waste your time, and we just ask you for that like and subscribe. So till next time, this has been another episode of Life's Third Act. Till then, take care.
You've been listening to Life's Third Act, a podcast for thriving in retirement. Sponsored by Tucker Allen, your estate and elder law advisors. Each week we discuss topics and answer questions to help you better plan for your future. For more information, visit tuckerallen.com. Subscribe and listen again next week for another edition of Life's Third Act. The choice of a lawyer is an important decision and should not be based solely on advertisements.